matter to come before the court this morning is Raymond Nemer versus Elliousa Nemer et al. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal if the appellant and wish to reserve any time. Please let me know when you get started. I'm keeping track of the clock. You can also see the clock is on the wall over there for your use as well. Please don't use the names of any victims of crime or minors. I don't know that that's really part of this oral argument. We'd like to make that advisement because the oral argument is being recorded and it will be posted on the court's YouTube channel. The courts have read your briefs. We are ready to see when you, the judges have read your briefs. We are ready to see when you are. Would you like to reserve time for rebuttal?
I would, Your Honor. I'd like to reserve 4 minutes of my time for rebuttal.
Certainly, thank you.
Thank you, Your Honor. Good morning. I'm Eric Zabrins, representing Lucy Bear in this case. Lucy is sitting in the gallery in the first row next to her mother. May it please the court. The trial court had 2 alternative pathways to get to the correct balancing of interest approach in determining what the proper disposition of the pre-embryos in question in this case should be. That approach has been adopted by courts in many other jurisdictions, including Tennessee, Pennsylvania, Colorado, Connecticut, New Jersey, and most recently Maryland. But the trial court erred in failing to take either one of those alternative approaches. The first pathway was to treat the form document that was given by the fertility clinic called a Declaration of Intent, that's Lucy's trial exhibit A in the record, as a contract between the parties, and then to interpret and enforce the contract in accordance with its clear and unambiguous terms. And that's why Lucy thought would be the case at the beginning of the trial, and that's why we stipulated that the Declaration of Intent was a contract between the parties. That's in 2 places in the record that we stipulated to that. In the first volume of the transcript at pages 72, 73, and in the second volume at pages 3 and 4. But then, after that, Nemer testified that contrary to the written Declaration of Intent he signed, he never consented, he testified, to the pre-embryos being awarded to the wife under any circumstances. He said he didn't give his consent for Lucy to receive the pre-embryos. She could not receive them without his further written consent. That was his view of the situation, and that all he consented to was that they should be donated to another couple for use in achieving a pregnancy.
Counsel, I just want to double check. When you agreed there was a contract, was there a stipulation or agreement that the issue before the court would be governed by that contract?
No, Your Honor, there was no further implication to the stipulations. The trial court was simply asking, did we agree that there was a contract? Now, maybe the trial judge had that in mind, but that was not part of the specific stipulation that we entered into. It would have been...
The other thing I want to ask, I'm sorry for interrupting, but
That's okay.
I know you agreed that there was a contract. Reading that in the briefs and the transcript. But then you were just starting to talk about how when he testified, then your other argument is there was no meeting of the minds in regard to a contract. Is that your argument, or is it that the contract itself was controlling but it's ambiguous?
Your Honor, it's both. It's both in the alternative. That either the contract means what it says in writing that both of them signed, which is what we had thought was going to be the case before Nemer contradicted that by his trial testimony, in which case we argue that the terms of the contract were not followed by the court because the court interpreted the contract only with respect to what Mr. Nemer testified was his intent, instead of taking the interests of both parties under consideration. Or, as Your Honor pointed out, there was no meeting of the minds, in which case the court still should have gotten to the balancing of interests approach. It should have been done either way.
Can I back up and take a wider view here? The case is captioned, and I haven't seen the record yet, but the case is captioned et al. Is the clinic a party?
Your Honor, the clinic was a party, and there were other defendants that were named by the Nemer action, but when it came down to the trial of the case, there were only the two married parties who were there and who were represented.
Okay, and a second question. It says that both parties agreed that the 14 frozen embryos are marital property and subject to distribution by the court. Is that true?
No, Your Honor. What we agreed to was that the 14 frozen pre-embryos were to be the subject of the court's decision, but we did not stipulate that they were marital property, and we don't believe that that's a correct characterization of pre-embryos. We don't think that they're marital property under the Ohio statute of what constitutes marital property. We don't think that they are human beings yet. We believe that they occupy a sort of middle ground, and that has been something that other courts have found. The Tennessee Supreme Court held exactly that. The Colorado Supreme Court held that, and so did the Maryland Court of Special Appeals, which is their highest court.
So would you characterize then the agreement, not that they're marital property, but would you characterize the agreement that you agreed that the domestic relations court had jurisdiction?
Yes, Your Honor, we did.
And that's because it's property?
No, Your Honor, it's because they were created during the marriage. There's no doubt about that. And they are subject to the order of the court, not as property per se, not as children, certainly, not yet, but again, as something that has characteristics of both of those categories and is appropriate for a domestic relations court to deal with when the parties are in the midst of a divorce proceeding.
And I'm sorry for keeping you, but I have one more question.
That's why I'm here, Your Honor, please.
I note that the order just says 7 embryos and 7 embryos, and it doesn't designate each embryo, they're unique. Is that a finality issue for the Court of Appeals, do you think? It doesn't actually tell us what goes where.
It's a very interesting question, Your Honor, and not one that I had previously thought about. I don't think so, because I think what Judge Hoffman was trying to do was trying to have certainly the appearance of fairness and equality between the spouses, but the end result is the same. It doesn't, as you saw, of the 14 pre-embryos, there are some who have a much better mitochondrial score than other ones do. Therefore, they have a better chance of a successful becoming a fetus and actually achieving a pregnancy, the lower the score becomes. There are 3 that are chromosomally abnormal. But the end result is the same. Whether Lucy got the 7 best, or she got the 7 worst, or she got a mixture of all, the court ordered that she turn them over to the fertility clinic for donation to another couple to be used to try to achieve a pregnancy instead of being given to the biological mother to do that. And the same with the 7 he gave to Ray.
How does the domestic relations, let's assume these are motor vehicles, how does the domestic relations court have jurisdiction to order the disposal or what happens after it's awarded to one spouse? Maybe that's not the issue we're here on, but it goes back to the initial question of the jurisdiction of the domestic relations court.
Well, that's interesting, Your Honor, because there has just been a very recent decision by the 11th District, one that only came to my attention after oral argument had already been scheduled, and we didn't have a chance to submit a supplemental authority to the court. I will after argument if the court wishes me to. And the dissent in the 11th District decision took exactly the approach that Your Honor is taking.
Okay, and I'm going to stop you there, only because it wasn't submitted as supplemental authority, and the other side won't have an opportunity, but if you can make your motions for submission of supplemental authority, and the court will deal with it. Thank you very much.
So if I may continue.
In Louisiana, pre-embryos are by statute children, and then a best interest standard applies.
And it's that way in Arizona as well, Your Honor, yes.
And also in Arizona, any pre-embryos would go to the parent who intends to make that become a child.
Exactly right, which is in our case Lucy, my
Right.
client. Yes,
So when you
that's,
think about those types of standards, because I don't think this court is bound by any standard at this moment. There's very little case on Ohio about this particular issue.
we would certainly agree with the court's conclusion that would follow what Arizona and Louisiana did, but I reminded the court that that was by statute, and it might be thought that it's more appropriate for the General Assembly to reach that sort of flat, no question about it result, rather than a court doing it. The courts that I have seen that have followed something akin to that approach have taken what we're advocating for this court to adopt, which is the balancing of interests approach. And in that approach, when there is a balancing of interest, for example, the Colorado Supreme Court in Rooks found 4 specific factors. 1, the intended use of the party who is seeking to preserve the embryos. In other words, the court in Rooks specifically held, and this is followed by the more recent Maryland case 2 years ago, was followed by the Davis versus Davis case in the Tennessee Supreme Court. In other words, the party seeking to become a genetic parent has a weightier interest in receiving the embryos than one who seeks to donate them or to destroy them. Yes, Your Honor.
I just want to make sure I understand, though, your position. For us to be able to use the balancing interest, we'd have to find that there was no contract control.
Yes, Your Honor, but it was also what the court should have done if the contract had been controlling, as the trial court found, but then it took only one side's interpretation of the contract into effect instead of the proper interpretation. And Your Honor, the proper interpretation is that Ray Nemer agreed that his biological child would come into existence, child or children would come into existence. There was either the possibility or the likelihood that he would have his genetic children or child in existence in the future. He already agreed to that. And then there were 3 choices from that agreement that this document, this declaration of intent provided, and they checked the first box. By the way, the other 2 boxes, to award for research purposes or to destroy the embryos, which were not checked, would have meant no biological child would ever have come into existence. But they agreed to the first box, which is that what would be presented to the clinic was a court decree directing the use to achieve a pregnancy in one of us, meaning one of the parties to the divorce, or for donation to another couple for that same purpose.
And counsel, I apologize, because I did not alert you that you had reached past your 4 minutes of rebuttal. I think we all became very involved in the argument and asked you many questions. You may proceed or reserve the remaining time as you see fit.
Yes, Your Honor. I'd like to reserve the remaining time and would ask the court to consider granting both sides a little bit more than the normal amount of time for this case, but obviously that's up to the court. Thank you, Your Honor.
Good morning, Your Honors. May it please the court, my name is Attorney Adam Morris on behalf of the appellee Raymond Nemer. For this court, this may seem like a complicated issue, but looking at the facts in this case, my client believes that it's fairly simple. This court needs to look at the declaration of intent that was signed by both parties and enforce the terms of that declaration of intent.
Counsel, let's start right there. In the declaration of intent, both parties agreed that these pre-embryos would become children, would become life-lending.
Both parties agreed that they could become, could
At
be,
least the chance would be.
could be implanted if both parties agreed at the time of taking that process for implementation.
I'm sorry, maybe I didn't say that as clearly as I should have. The way I understand the memorandum of understanding is, or notice of intent, is that they checked a box that either gave the pre-embryos to the couple, and they could then implant with either one of them, depending on what their circumstances were, or to another couple. So always the intent was for these children, they both agreed, the intent for these embryos to become children, is what I'm trying to say.
Yes, Your Honor, I would agree with that
Okay,
statement.
that's what I wanted to make sure about, what was the intent in regard to that, so we all agree on that.
Yes, we all agree that there's only two things that could have been done with these embryos, and that would be either donate them or use by one of the parties. Now, based upon the terms of the Declaration of Intent, there's, right on the front, it says there's 4 different alternatives. Right on the front of the Declaration of Intent, there's 4 alternatives that the parties could choose. And that's either they could agree to discard them, which they didn't agree to do under this provision. They could agree to donate them for research. They did not agree to do that. They could donate to another couple, okay? And that's an option. And the 4th alternative was use by one partner with the contemporaneous permission of the other for that use. And that is right, the first thing you read in the contract. So that's the 4 alternatives.
Well, you're talking about, in general, in the notice of intent. You're not talking about where they're actually checking the boxes.
Yes, Your Honor, I'm talking about the front of the contract where it starts to lay out the terms of the contract. And this is what Mr. Nemer and his wife at the time read. These were the terms that they were understanding. And one of those terms was that these embryos cannot be used by either person without the contemporaneous permission. And then, farther down on that page, it says note. And that note indicates that it's this exact circumstance. In the event of a divorce, these embryos cannot be used without the express written consent of both parties. And it even says, even if a donor gametes are used. So it's talking about this exact scenario where the parties enter in this contract, they've fertilized the embryos, and they enter into a divorce process. The contract, right on the front page in the note, almost like a warning sign, says these cannot be used without the express written consent of both parties.
And that's a general clause that's in the contract, right?
That is a general clause.
Wouldn't you agree that the specific clause is in case of divorce, because those are special circumstances, and so there can be different, because they could have agreed at that point to dispose of, they could have done any number of things with the pre-embryos. So I guess I'm wondering if the controlling clause should be the one that talks about in the event of divorce.
Well, this note here does talk about an event of divorce. Doesn't require them to check a box, but it's kind of a warning sign right there. But then farther down the contract where you do check the box and the specific language regarding an event of divorce, it says that basically the claimant will be presented with a court order or settlement agreement which will allow for use by one of them or donation. Now, you cannot read this contract and make that note on the front page meaningless under the rules of contract construction. In order for these provisions to be in effect, there's only one possible result when you get to that check the box, and that is, let's think of an example where Ms. Barrett could use them. An example would be if the parties enter into a settlement agreement, and in that settlement agreement, they agreed that she could use the embryos. That's a possibility. That wasn't this case. Outside of that possibility, there's only one other potential outcome in this case, and that would be that they are donated. Without the two of them agreeing in a settlement agreement, if you read the contract as a whole, there's only one possibility. And that's essentially what happened in the Arizona case that I cite in my brief, Terrell v. Torres, is the court essentially looked at the same contract, the same form contract. And they admit it's not a perfect contract. It's not. I don't think anybody would say that. But they did that analysis. And they, under that analysis, looking at the provisions, you have to read the contract as a whole. And by reading the contract as a whole, there's only one potential outcome.
But counsel, that was what I was getting at. Obviously, you read a contract as a whole, but there are also other means of interpreting and reading the contract, and one of them is the specific will control over the general. So that was one thing I wanted clarification over. The other thing is in reading the contract, because one of their arguments is there is not a meeting of the minds, and I'm wondering if by checking the first box, all they did was agree to agree. In other words, agree to make a contract in the future if they were in a situation of a divorce. There really wasn't any set agreement as to how these embryos, pre-embryos, would be handled, correct?
Let me go to the first question about specific versus general.
I'm sorry, I asked two at once.
Yeah, the specific versus general, I agree that's as this court indicated, that is a rule of contract construction. But looking at the specific, you're looking at that provision, and that provision basically says a court order or settlement agreement will be presented allowing for these two possible options. But if you're just looking at that provision, that doesn't necessarily answer the question for you. And I think this gets to your second question. You've got to go to the rest of the contract to answer that question for you. And the rest of the contract answers it clearly. Mr. Nemer read this contract, as his former wife did, and the terms on the front page could not be more clear. These embryos will not be used without the contemporaneous permission of both parties. So, going back to your specific versus general argument, you go back to that provision and you say, okay, if these cannot be used without the contemporaneous permission of both parties, there's only one potential outcome, and that would be the donation of those embryos.
Do you think this case implicates Ms. Nemer's rights, though? Her individual rights, or rights, other things other than divorce and the classification of these three embryos as property?
Yes, Your Honor. I think this is an issue that involves both parties' constitutional rights. It's not a typical issue that we deal with in domestic relations, but it does involve constitutional rights of both parties. And that's why the case law around the country has essentially adopted this contractual approach. Because by contracting, you're helping to alleviate some of those constitutional issues because you're laying out your intent in that contract. And that's specifically what the courts cite to, is that we are essentially using this contractual approach to try to relieve some of those constitutional issues. So yeah, that's a very good question.
But counsel, that was my question, I think, to begin with. How have they agreed in this contract, call it a contract or whatever, how have they agreed to deal with the issue of the pre-embryos if there is a divorce? Because they don't come to a specific, they don't just say you can check a box that says dispose of them, implant them. You have either donate them or allow either side, either husband or wife, to use them, if they agree. So guess my point is, you're really putting it, when they can't agree, you're really putting it back into the hands of a judge to make that determination, because there is no contract between them. And if there's no contract, then why would we be using a contractual approach and not balancing test?
I guess I would disagree that there is no agreement on this contract, because as I've argued and argued in my brief, if you read the contract as a whole, there is an agreement. And the agreement is that they're either going to settle this case and agree that either party can use them, or they're going to have to be donated. And looking at all the terms of the contract, you know, it's my client's position, and this is the position adopted by the Arizona Supreme Court, there is an agreement, and the agreement is that essentially these have to be donated because that's the only potential outcome that would make the contract make sense.
Or at least would make it a binding contract.
Make it a binding contract. And let me just go back to that issue is when we were in the trial court, both parties agreed this was a binding contract. Neither party ever argued that this was not an enforceable contract. And my esteemed colleague argued that this did not become a binding contract based upon the testimony of the trial. These were arguments that were made throughout the briefing of this case. My client's interpretation of the contract, and Ms. Baer had her own interpretation of the contract. And at the conclusion of oral arguments, essentially said that you can either adopt her interpretation of the contract, or if you don't adopt her interpretation of the contract, then we want you to do this balancing test. I think that is kind of getting 2 bites at it at this point in time. You can't go to the trial court, tell the judge this is a binding enforceable contract, and then come up to the Court of Appeals and have a completely different argument on the issue, and now claim that this is not an enforceable contract. Just going to the balancing test, there's essentially 3 different methods. There's the contractual approach, the balancing test, and the contemporaneous mutual assent approach. Okay? The contractual approach is probably the majority position, and the balancing test and the contemporaneous mutual assent test is the 2 minority positions. We would argue that looking at the intent of the contract, even if this court were to not necessarily adopt our interpretation of the contract, this court should look at the intent of the parties laid out in the Declaration of Intent and adopt the contemporaneous mutual assent approach, which essentially means for these embryos ever to be used, both parties will need to consent to the use of them, or they stay in storage. We believe that would be the alternative approach based upon the facts and the circumstances of this.
Do you mean stay in storage indefinitely?
Potentially, until the clinic determines that they're no longer viable.
Does the clinic have a right to these 3 embryos?
The clinic has a right to destroy the embryos at some point in time. I believe it's after 5 years pursuant to the contract. The clinic would have a right to destroy the embryos.
I had asked opposing counsel if the court's statement in the judgment entry that reads both parties agree that the 14 frozen embryos are marital property subject to distribution by this court is something that they believe to be true. I will ask you the same question.
I think under the current case law in the state of Ohio, there's only one way to look at them, and that is as property, and they were created during the marriage, so as marital property. And Your Honor, to your question about whether this is a final appealable order, I wanted to get to that. there is a provision in the decree that says that Ms. Barry would have the ability to select the first 7, and then Mr. Nemer would have the ability to select the next 7. So there is a ability to determine, who gets which embryos.
Thank you. I'm going to let you proceed a minute over time. Well, at this point, 2 minutes over time, and we're going to give that other minute also 2 minutes to Pleasant Side, unless you feel like resting.
I think at this point in time, unless this court has any additional questions, we appreciate your time and attention to this case. It is an important matter for both parties, and I think based upon the information that you have in front of you, you make the appropriate decision.
Thank you, Counsel.
Thank you, Your Honor. Judge Hensel, the clinic has no right to the embryos, no right to keep them, no right to do what the clinic wants to do with them, other than what Mr. Morris mentioned, the right to destroy them, which is something that obviously my client does not want to see happen. In the meantime, while they're being kept in cryopreservation, my client's paying for it because the clinic charges for that.
Counsel, would you agree that it's a 5-year term in regard to disposing of them?
I do believe that that was what was
Okay,
in
and
the
where are we at
declaration of
now
intent.
in regard to time?
Well, the last round of IVF was done in 2019. No, 2018. 2018, excuse me. So we would be coming up to 5 years this fall, because the last round was over in November of 2018. This divorce action was brought in January of 2019.
And there wasn't, I assume, any stay that was issued or anything in regard to when the clinic was a party?
That's correct. There was none. The Terrell case, the Arizona case on which Mr. Morris relies, was of course overruled by statute, as Judge Lanzinger asked me about in connection with Louisiana. Judge Carr, I think you have it exactly right in the questions that you put to Mr.
I was just going to say, I asked questions.
I understand, but I think those are the exact right questions. And the answers are different from what Mr. Morris told you. When he is talking about the 2 provisions that he mentioned in this declaration of intent on the first page, those are in the nature of whereas clauses. They would be like a whereas clause in a formal written contract as a preamble to getting to what the terms and provisions of the contract are. In this case, this declaration of intent talks about 5 future scenarios, one of which is the divorce or dissolution possibility. The actual contractual terms, we agree, etc., come with the 5 different sections of the document and the boxes that need to be checked in each section. And the boxes that obviously are relevant to this matter is the box on the section for divorce or dissolution, which we've already discussed. The box that was checked was, yes, I agree to a general provision, and by the way, that's what this general provision note, Mr. Morris talked about it as though it was a warning sign, I think he mentioned. It's in the nature of an explanation or instruction about what the remaining terms are going to be. And the provision that he quoted was, for example, in the event of a separation or divorce, embryos cannot be used to create a pregnancy without the express written consent of both parties. To create a pregnancy, Mr. Nemer agreed, as did his wife at the time, to the creation of a pregnancy from these pre-embryos. Then that begs the question. Then if both sides agree to the creation of pregnancy, in whose uterus will those pre-embryos be implanted to try to achieve that pregnancy? Are we going to implant them in the uterus of the biological mother, who has already expressed her uncompromising desire to become a biological parent? And at her age and with her health condition, this is her last best chance.
And with that, counsel, I've allowed both sides a little extra time. Thank you very much.
Thank you. We ask the court to reverse, obviously. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Supreme Court website.